Hello and welcome to Chapter 4 on criminal liability. This is going to continue our examination of the criminal law. Just as a reminder, we are going to turn the focus here a little bit to North Carolina law. So when we're talking about conspiracy or solicitation or points like that, I will try to divert a little bit to give you some practical examples for how North Carolina handles these issues. Okay, so again, like all chapters, there are going to be some learning objectives. These are provided by the textbook itself. Some of them match what we're hoping to accomplish here at Wake Tech, some of them don't, but they all cover broad themes and ideas that we are covering in this chapter. So it's worth taking a look at them, but they're not actually assignments or required, certainly, to review this, and we've got 2 pages of them. We've got 7 of them listed. Okay, so let's jump into the meat of this chapter. Let's talk about criminal liability. If you think about committing any act, much less a criminal act, there are often distinct segments or parts to it. So let's ignore crime for a second and think about proposing marriage. So the first thing you might do is you might have the idea, should I marry someone? And the second thing you might do is you might plan your proposal. Then you might make your proposal. You might ask the other party to marry you. And then if they accept, of course, you're going to carry through. Now there's a couple things hiding in that example. There's the solicitation of the proposal, which in itself, if we're talking about a crime, the solicitation of a crime can be a crime. And then there's the actual completed event, the marriage. And the completed event can be a crime. So any party who is associated with anything beyond just having the idea, the plan or the attempt to commit a crime, can have criminal liability. So we call these people different names in different jurisdictions, and sometimes, as I said, the mere attempt to commit a larger crime is a separate crime itself. So an example here in North Carolina would be prostitution and assignation. Prostitution is the actual act. That is the performance of sex for money. And that would be typically what you would charge the prostitute with. And if we look at the classic example of prostitution, and I know there are male-to-male prostitutes and female-to-male, but if you look at the classic example of a man soliciting a woman for sex, when he asks her to have sex for money, that, if there is an agreement and it's not a joke, and we'll talk about those issues, can be a crime. That is an assignation. When she consents and accepts money and performs the act, that's another crime. That's the prostitution. So any party associated with the plan or the attempt can have liability. Sometimes what we do is we say there are different stages of crime. So the first stage, the idea to commit the crime, that is not a crime. Anyone can think bad thoughts. You can be having a bad day and say, oh, I want to burn down Wake Tech. I want to blow up the Brooklyn Bridge. I am so mad at my kids, I just want to go home. And you might use a phrase you don't mean. I'm going to murder that person. I'm going to kill him. You don't mean that. You're just having an idea. Ideas alone are insufficient to charge a crime. Now, the stage at which criminal activity might, and I want to emphasize might, become chargeable is when you are planning or preparing for it. So, planning or preparation, or solicitation, or conspiracy, all things that we're going to look at in a little bit, these are all precursors to the actual, not crime, but the attempt of the crime. Now, there are instances where you have, and this flowchart here talks about impulsive or spontaneous crimes where there is no planning or preparation. So for some crimes, we just skip the whole planning or preparation stage. Now we go to attempt of crime, because sometimes we attempt to do something illegal, but we fail. So you might attempt to kill someone, you might attempt to burn down a building, but you might not be successful. Simply because you failed doesn't mean you didn't actually commit a crime. If you attempted a crime, but that attempt failed, then usually you are chargeable. Now in North Carolina, the typical charge would be one level lower in punishment than if you had completed it, unless there is a specific crime that says this is attempted arson, attempted burglary. So if you attempted to commit a burglary but failed, then you would be charged with attempted burglary. That would, let's just make up, let's suppose it's a class, it's a D or E, it depends on all sorts of factors like whether it's night or stuff. So let's suppose you were going to be chargeable and face 5 years in jail. But because it was an attempt and it wasn't completed, we'll charge you at a lesser level, and that might be 3 years in jail. Then, of course, if you attempt the crime and the crime is committed, you burn down the building, you kill someone, you rob the house, then the crime is complete. And when we say it's complete, it means that it meets each and every element of the crime. And as we get into later in the text, as we look at specific crimes like homicide, we look at the different elements of it. I'm going to mention those a little bit in the last chapter, or burglary, which I've mentioned specific elements of: breaking, entering, occupied, dwelling at night with intent to commit a felony therein. If you commit each and every one of those elements, you've committed the crime. Now, after a crime's been committed, it doesn't mean that all possible liability about it, criminal liability, disappears. Because there are post-crime offenses, such as, and a big one is resisting, obstructing, or compounding of crime, harboring a felon, aiding and abetting after the fact. All these are terms you see scattered throughout the law in the different states. And we'll hit all those before, but here is a good flow chart. This chart's really pretty good. It takes you from, I have the idea, to I'm going to prepare, I'm going to go out and buy a gun, I'm going to go out and do something, to I attempt to commit the crime, I shoot at someone, I complete the crime, they die, okay, to post-crimes, I'm running away and somebody helps me. Okay, let's talk about intent. Intent to commit a crime, which typically is demonstrated, in fact has to be demonstrated by some type of physical act or statement, is a crime in and of itself often. It is even possible to commit a crime even though you didn't intend to harm anybody. So, for example, years and years and years ago, I worked out at the RDU airport, and I was a screener for security. And sometimes people would make stupid statements when you said, "Can I search your bag?" Or "I'm going to search your bag if you're going through security." They'll say, "Oh yeah, I put a bomb in it." Well, I would have to remind them at that point that there is a federal statute that makes it a crime to even make a joke, a false statement about the presence of a bomb in a civil aircraft. So you might have meant it as a joke, but we can criminalize jokes in this regard, believe it or not. That might seem a little extreme, but think about the person. If you say, "Yeah, I got a bomb in it," and you're deadpan serious, "Yes, there's a bomb in my bag." Well, now I might have to hit the security button. People might have to come running. We're talking about a tremendous amount of effort and resources that would have to go into dealing with your little joke. So it's actually a criminal act under federal law, that's U.S. Code 18, U.S. Code, Section 35B, to make a false statement about the presence of a bomb in an aircraft. Okay, let's move on to criminal liability. Obviously, what we want to do is we want to prevent the completion of the crime. So we would like to catch people and be able to charge people before they've completed it because there's less harm to the society. So we have created at least 3 separate areas where the crime does not get completed, but you commit a crime which we usually charge at a lesser level than the completed crime. And we're going to talk about solicitation, conspiracy, and attempt. Now, of course, these are all preparatory. Sometimes we simply call these inchoate, and I know it doesn't look like it's pronounced that way, but it is, inchoate offenses or inchoate crimes. You attempted to commit murder. You formed a conspiracy to commit treason. You solicited someone to rob a liquor store. So again, if we go back to that flow chart for 1 second, you'll see that the solicitation, the conspiracy, the preparation or attempt can be a crime. All right, inchoate questions. Where and when does non-criminal conduct become conduct by further of an act of a suspect? That's a very roughly worded sentence. Which of the preliminary offenses, if any, has the suspect committed? When does the commission of the principal offense begin so as to allow the state to charge either the preliminary or the principal? So one of the things we can ask is, when does something really cross the line from non-criminal conduct to criminal conduct? So let's take an example. Let's suppose you're very angry at someone, and you've decided, you know, I want a gun. And maybe you have an ill-formed idea. Maybe you even just thought, I'm going to kill Fred. You know, I'm so mad at Fred, I'm going to kill him. Okay, you drive to the gun store. You purchase a gun. Now, at that point, have you committed some part of a preparation, a plan, a conspiracy, an attempt to commit murder? And unfortunately, there's no hard answer there for every situation. I think you have to look at each situation and say, okay, would a reasonable person believe that this fits in one of these categories? And then, of course, you have to ask, well, what preliminary offense have you committed? Is purchasing a firearm for the purposes of killing someone part of attempted murder? And you might say no. Well, okay, let's suppose I wanted to commit mass murder, and I went and I purchased a weapon of mass destruction that had no other legitimate purpose except to kill a lot of human beings at once. Now, would you say I was getting close to it? And I'll take that a step further. Let's suppose I went and I bought bomb-making materials. I even assembled bombs. Now I've got a weapon. I've never used it against anybody. Now would you say that I've committed some sort of attempt? Okay, so we can ask when we say we've really moved to the point of attempt, or conspiracy or solicitation, and when we've gone from that attempt stage to the principal stage, and when can we charge? Okay, so let's look at one of these large categories. Let's look at solicitation. Solicitation is an attempt to get another person to commit a crime. Essentially, solicitation is an attempt to commit a conspiracy. One of the things about solicitation is it does not have to be successful to become a crime. It's still a crime if the person you solicit refuse. So if I go to someone and I said, I'll pay you $1,000 to burn down that school. I will pay you $10,000 to blow up that bridge. I will pay you $100,000 to kill that person. Even if I'm talking to a police officer undercover, or an FBI agent, or someone who has no intent of doing any of those things, it is still a solicitation to commit crime. Now, why do we make solicitation a crime? Well, First of all, it prevents the crime from occurring. It protects the public from some sort of inducement to engage in it, and it allows us to identify those people who may lack the capability of committing crime but have the morality that they're willing to do it. So solicitation can be a crime. And again, most states might charge at a lower level or sometimes have separate crimes of solicitation. Okay, let's talk about conspiracy. Conspiracy crimes are agreements between two or more people to engage in an unlawful act. Now, this is the oldest category that you can look at of crimes that didn't come to fruition, called preliminary crimes. If you go back to the English common law, you'll see that the idea of conspiracy begins to develop in the Middle Ages. And some of these conspiracy charges are very useful, particularly for kings and people in power trying to suppress potential rebellion. But quite quickly, besides the political utility of this, it becomes a useful part for groups of people that are getting together to do bad stuff. So a conspiracy is an agreement to commit an act in the future, okay, that is criminal with the intent. Now, even if the planned crime is not attempted, the agreement itself constitutes the crime of conspiracy. So you might hear the term conspiracy to commit murder, conspiracy to blow up the Brooklyn Bridge, conspiracy to commit an act of terrorism. So, for example, most acts of terrorism are not completed. Most people plan them and maybe get to a certain stage, but they're not completed. So why have the statutes? Well, because, and this is, I not love the wording of this. It looks like we have the statute because it increases the potential harm. No, what we're saying is conspiracy increases potential harm to society. One person is dangerous, doing something bad. Two people is even more, 3, 4, 5. The more people you add to a group that is doing something really bad, the more damage they can do. 2, if you've got a bunch of people willing to commit a crime, it becomes more difficult for people to withdraw. One person's committing a crime, he can change his mind like that. 2 people, a little bit harder. 3, 4, 5, very hard. Also, we're social creatures. 2 and 3 people can accomplish things that one person can't. So conspiracy increases the chance that a crime is successful. Also, conspiracies can be more difficult to detect than when one individual does it. If we're going to blow up the Brooklyn Bridge and I go and buy the nitrate powder and you go and buy the truck and Bob goes and gets the plans from the office. Well, now if we're trying to figure out is someone going to blow up the Brooklyn Bridge, we have one guy who just bought some fertilizer, some nitrate. Nothing unusual. He might show up in the radar. One of 10,000 people who did it. Then we say, well, did anybody try to get plans to blow up the Brooklyn Bridge? Yeah. 500 people got plans for the Brooklyn Bridge. Artists, people, architectural students, and Bob. But Bob isn't on our list for the nitrates, so we can't tie them together. It makes it more difficult to detect. Okay. One of the things about 2 guilty people is under the old common law, and this pretty much is the approach in North Carolina, but let's stick a pin in that. Both conspirators had to have a guilty mind. So A solicits B to rob a bank. B agrees, but secretly intends to call the police. He's not really agreeing. At the common law, you couldn't charge conspiracy because no real conspiracy comes into existence. Now, the modern approach has been to really get rid of that, essentially making it okay to attempt to form a conspiracy. North Carolina is not in love with that position. Certainly, if you have one police officer and one criminal, and I solicit just the police officer, and the police officer agrees with me with no intent to commit, it's very difficult to charge conspiracy in that case in North Carolina. The third thing about two guilty people is you don't need to conspire. If you've got two people agreeing to a conspiracy, A says to B, let's rob the bank, B agrees. You arrest A. Maybe B can't be found. Maybe B has been given a plea bargain. Maybe B is not charged at all. Maybe he's a minor. That's okay. You can still charge A with conspiracy. You couldn't if B was a cop in North Carolina, because you wouldn't have a real conspiracy. But if he can't be found, if he's dead, if he's not charged, you still can charge A with the conspiracy. Conspiracy statutes are designed to prevent criminal partnerships. Now, you don't tend to see the word partnership used criminally very often. Conspiracy can be looked at as a partnership in crime. The bilateral approach, that is, you have to prove two or more people. North Carolina pretty much sticks to that, but I don't think I've seen a lot of appellate court language calling them partnerships. All right, well, what about corporations and people? What is people? Because people, there's a few things to look at here. Can a husband and wife, who in some cases under the law are considered joined, not as separate as I am, say, with the president. I mean, we're two separate people. But my wife and I, for example, we can own property uniquely together. We have certain rights under estates. So what about husbands and wives? Nope. Under conspiracy rules, that's fine. Husbands and wives can agree to commit conspiracies. What about corporations? Well, if one person in the corporation decided to commit a crime, it's not conspiracy, even if he's the head of the corporation and directs the corporation to do something. It becomes a conspiracy if two or more people inside the corporation agree to commit the crime. Then it's a conspiracy. Okay. You can look at this case of, it's kind of a tragic case where two fifth graders faced trial for a murder plot. Two fifth grade boys were charged with first-degree murder, tampering with a witness, a juvenile in possession of a firearm. I think let's suppose this was strictly a New York or a Raleigh case, make it easier for me. Let's see, fifth grade would be, what, 10 or 12. Okay, so it's a juvenile case, certainly, depending upon their age. And then you have to ask the question, okay, you've got some competency issues. Was this just two people, two fifth graders? And it's not if you look at that case, but is it just two people saying stupid stuff? Is it just two fifth grade boys? So you have to prove, that it's a true intent, and then you can look at those other crimes. But it's worth looking at that hyperlink. Okay. One of the things that usually was required was an overt act. Now, many students confuse overt act with element of crime. That's not true. So let's go back to the original example I used about committing murder by buying a gun. And let's look at that as kind of our framework to address the overt act issue. Historically, the only thing you had to prove in conspiracy was the agreement. You didn't have to prove that anybody did something. But most states require that just sitting around talking about something, even sitting around mentioning it, even the agreement, we want something more overt. We want something demonstrable. Almost any act you can think of is enough. If I say in a conspiracy or partnership, I want to kill my wife, and I go to the bank and I take out $10,000 to pay you, well, taking $10,000 out of the bank is not a crime, but that would be an overt act that would show that I intended to commit it. Now, there are some statutes where you don't have to show overt acts. And one of the things about the war on drugs was that Congress really went in and sliced out quite a bit of the overt act conspiracy for it. So if we look at Title 21, Section 846, which is conspiracy to violate federal drug laws, there's no requirement of proof of any overt act, only a requirement that you conspired. So you can get rid of the overt act. Most state law really requires it. Let's talk about RICO. RICO stands for Racketeer, Influence, and Corrupt Organization. This is, I would say without question, the primary federal statute which is used to attack organized crime. I would probably say terrorist, it's used a little bit, and any conspiracy or grouping of individuals to commit a crime. So we can look at a couple cases there. Salinas versus the United States, a person could be convicted of conspiracy without having taken any acts, so long as they agreed. And Whitfield versus the United States. Some statutes do not require overt acts, but only agreement. So, having said that, I will say this. Typically, an overt act is something that every prosecutor likes to see, because it shows that it's not a joke. It shows that it's a serious thing. And if you can't find that, that can be tough to get a conviction, not an indictment. The Wharton rule says that some crimes cannot be committed alone, but require two or more people. If that's the case, conspiracy is not typically charged. So examples here would be gambling. You can't commit that crime by yourself. Prostitution, you can't commit it by yourself. Receiving a bribe, you can't commit it by yourself. Distributing illegal drugs, you can't commit it by yourself. And I know there's a drug statute back there. But the Wharton school says that the crime of conspiracy cannot be charged if the number of people involved in these are only those necessary to commit it. So, example here. If I am a criminal and I am going to sell you an ounce of marijuana in a state where it's illegal, you typically would not be able to charge them with conspiracy to sell drugs. Now, if one of them was a police officer, solicitation might be more popular, but you need two people to commit that act. That's the Wharton rule. Impossibility, abandonment, and withdrawal. Now, this law is evolving. One of the things I think has happened almost unnoticed over the last few decades in the United States is that prosecutors want to be able to charge conspiracy more. They want to criminalize more things. And Congress and the state legislatures have gone along with this. So let's look at the United States versus Jimenez-Recio. The court reversed a Ninth Circuit Court of Appeals decision that conspirators could not be convicted of crime if the object of the conspiracy had been defeated before they joined the conspiracy. So they essentially, you had a group of individuals who wanted possession of illegal drugs. However, before the conspiracy was over, I'm worried about before it was begun, the police had seized the drugs. There was no possibility that that would go forward. And the court said, well, that's okay. We can still charge them with conspiracy to possess those drugs, or conspiracy here, even if the crime cannot be committed. Even if a conspiracy is abandoned, or one of the conspirators withdraw, you still have the conspiracy. So you and I agree to blow up the Brooklyn Bridge. After thinking about it, maybe there's an overt step forward to make everything easy. You go out and get the plans for the building. I say, I'm done with this. Okay? I'm going to withdraw from the crime. I don't want to be involved. Well, you've already committed the crime. You've committed the crime of conspiracy. You haven't committed the actual crime yet. And just because you say you're not going to do it doesn't mean, basically it's the old thing when you were a little kid, no backsies. Okay? However, there is a limit on how long. If 5, 10, 20 years ago you thought about committing a crime, you talked to someone, you kind of agreed to do it, you formed a conspiracy to do so, and you withdrew, and it's 5 years later or 10 years later, and it's discovered, you could show, and it's usually a 5-year statute of limitations, you could show that you had abandoned the conspiracy, and you could not be charged. So we have the 2013 case of Smith versus United States, where the Supreme Court said that the defendant had to prove he withdrew from the conspiracy more than 5 years ago, which is the federal statute of limitations. So it actually placed a rebuttable burden, rebuttable presumption that he didn't withdraw in time. Okay, we've talked about conspiracy. Let's talk about attempt. The crime of attempt is very frequently charged because there was a physical proximity of an individual. So attempted murder, attempted rape, attempted burglary. Usually, if I conspire to someone to rob an apartment, okay, and you caught me while I was just out buying the ski mask, you charge conspiracy. But if you caught me as I was jimmying open the front door, you would charge attempt. Even if the crime was not actually completed or carried out, an attempt poses criminal liability. All right, so intent can be really important here, the mens rea. If the base crime has specific intent, then the attempt has to have specific intent. Example, we have in North Carolina a statute that's called possession of burglar tools. And assuming you're not a locksmith or something, you're not supposed to have certain tools. Okay. But if I caught you with a lockpick on the street, that would be the specific crime, simple possession. Okay. But you couldn't charge me with burglary. Okay. On the other hand, if you caught me in the hallway of the apartment with my tools in the door, then yeah, you could go from the crime I've already committed, possession of burglary tools, to attempted burglary. Now, there are some crimes that we don't care. We don't care about your intent. So, if you sold, for example, contaminated food, it is a crime whether you know it or not that it's bad, believe it or not, in some states. All right. States differ on how the act requirement in attempt is found. Many states require a substantial step forward. This is the most common test. So a person is guilty of an attempt if they make a substantial step forward. And again, these steps do not have to be criminal in and of themselves. It could be gathering preliminary information. The example here is getting the witnesses, the address of witnesses, arranging for financing for hitman, or sending letters to arrange hits. All those are substantial acts, but getting someone's address is not a crime, but it would be a substantial step forward to commit a crime, an attempt. It is not a defense to say something is impossible. Your book gives the example, you go to shoot someone, you take the gun, you point it at them, you pull the trigger, and it clips on an empty cylinder. Did you attempt to commit murder if the gun was unloaded? And the answer is you did. It doesn't matter if the attempt was impossible. If you believed it to be possible. Now, there can be legal impossibility. So if what you're trying to do is an attempt to do something that's not illegal, not a crime. So if I was going to sell you something that I thought was child pornography, this is the example your text uses, but in fact are not pornographic. So I just show you a picture of two children at the beach. They're in their bathing suits. And I say, oh, this is pornographic. I'll sell you this. Since it's not pornographic, there's no attempt to distribute illegal material. Again, it doesn't matter if people change their minds. Conspiracy crime is complete when the agreement is released. Complete. Okay, so here's your discussion question. While friends were finishing a dinner on the patio of a home, a man wearing a hood and a gun bursts in the patio, demands money, threatening to shoot them if his man's not made. He took off his hood and reached for some barbecue. After eating a few bites, he said it was very good. Partygoers offer him more food. He puts his gun in his belt. He apologizes, told me he had come to the wrong house. He left, so he doesn't take anything. Did he commit attempted robbery or robbery? Can he argue he abandoned it? Well, did he take a substantial step forward? He sure did. Now I'm going to leave this up to you, and I think you can think about this. Did he complete all the elements of the robbery? It wasn't an impossible thing. Did he commit attempted robbery? When he abandoned it, did that end? I mean, I think you would see, well, I'm not going to tell you, but I think you could make an argument for the robbery and the attempted robbery. I don't think that he can say, it's all right, I didn't hurt anybody. Okay, I had mentioned principles in the last lecture, and I said this is a principle. Now, you will sometimes and often hear principle of the first degree, principle of the second degree. Those terms, I would say, are probably falling out of use. Principle of first degree is someone who actually commits the crime. You rob the bank, you blow up the building, you shoot the person. Principle of second degree, you're present, but you don't do everything. You aid and abet, maybe. Maybe you drive the getaway car at the bank. In almost all cases, principles in first degree or principles in second degree, you're present at the crime, you know what's going on, you're participating in it, but you don't do every element, you're still guilty of the whole thing. Now, there are aiders and abettors, something called accessories, who are liable if they've engaged in a conspiracy or they've urged, counseled, mentored, or planned to commit the crime. Okay, so we have a couple different types of accessories. Accessories before the fact and accessories after the fact. An accessory after the fact, well, I guess we need to logically start with before. So you know a crime is going to be committed, and you aid them in preparing it, but you're not there. Because if you're there, you're going to be a principal. So I come to you and I say, I want to blow up the Brooklyn Bridge. I'd like to buy some nitrate that will operate as a bomb. So now you know that I'm buying the nitrate to blow up the Brooklyn Bridge. If I sell it to you, knowing it, okay, and not for my own sake, and I'm going to call the police as soon as you're out the door or something, different story. But if I sell you that, I'm an accessory before the fact. Now, on the other hand, someone blows up the Brooklyn Bridge, they come running, you're running a hotel. Someone comes into the hotel, says, man, I'm really tired, I need a room for the night. You say, sure. Sign him in, goes up, gets a room for the night. Now, you don't know, but he's the guy that blew up the Brooklyn Bridge, and he's hiding from the police. You're not an accessory after the fact to the crime. But if he comes in and you recognize him from a wanted poacher, oh, this is John Smith, the guy who blew up the Brooklyn Bridge. He wants a room for the night and essentially to hide from the police. You give him a room for the night, you don't call the police. You're an accessory after the fact. The general rule was you couldn't try accessories before or after the fact until you convict the principal of the act. Because if that turns out not to be a crime, then what they did was not a crime. Okay, you can go to this YouTube and look at people discussing criminal liability for spouses and partners. And then ask yourself the question, should we make spouses liable for not reporting the crimes of their other spouses? And does it become aiding and abetting after the fact? At what point do I have to inform? Okay. Typically today, accessories and parties who can be held liable is essentially what one did, they all did. So I'm going to go rob a liquor store. You drive me down to the liquor store in the car. I go in the liquor store. I pull the gun. I point the gun. I get the money. I come out of the liquor store. We drive away. You didn't point a gun. You didn't interact with the person, but you were there at the crime. Therefore, what one person did, me in this case, you also did. You also could be charged with armed robbery, even though you never had a gun. Now, in North Carolina, if I shot that individual and he died, the murder felony rule would be triggered. So you never shot, you never met him, but I killed, and we had agreed on the crime. You could be charged with first-degree murder. Here's another example your book gives. Defendant Watts guarded the parents of a teenage girl while his two friends raped the girl. Watts is convicted of two counts of rape in concert, not a term we use in North Carolina, because he aided and abetted. Yeah, under murder felony, you'd be charged. Well, not a murder felony, but you'd be chargeable. Under the common design rule, when two people have a common plan to do an unlawful act, whatever is done in furtherance, they all can be charged. This goes back to that example I just gave you with robbing a liquor store. Under the Pinkerton rule, a co-conspirator can be liable for crimes even if they didn't know I was going to do them and didn't agree to commit them. But if they were foreseeable, yes. So if I said, don't kill anybody when you go in the building, but I know you're going to be armed. Well, I never agreed for you to kill people. But since I agreed to you going in and robbing the building, that's enough. Persons can be guilty of unforeseen acts during the commission of a crime. All right, let's talk about post-crime offenses. These are things, the crime has occurred, you didn't conspire, you didn't solicit, and now you're helping the person escape. The language in North Carolina is you're helping them escape detection the crime occurred, arrest for the crime, or prosecution for the crime. So different ones could exist. They could be obstructing justice, false reports, misprisons of a felony, failure to report a known felon, harboring or aiding felons, or communicating with jurors with the intent to influence them. And we do this because we want all the facts to come out, and we want to know the truth in the system. Now, it's a little bit more complex than this because if, let's suppose I'm standing at my picture window and I look out in the street and I see a bad guy, you know, classic bank robbery. He's got a little mask and he's got a little bag that's got a dollar sign on it. He's dressed in a striped shirt and he's running down the street. So he robbed a bank. And I see that he's heading west. And a police officer comes up to me and he goes, "Did you see a bank robber?" And I say, "I don't cooperate with the police, I'm sorry." And he says, "You got to tell me." Well, if I said, remember the bank robber was heading west? Oh yeah, he was heading east. Now I've committed a crime because I have assisted him actively. But I don't have to go out and help the police. Now, it's possible I could be subpoenaed and ordered, but just because a police officer gives you an order doesn't mean you always have to obey, although I would advise that you probably are going to get arrested if you don't. Certainly, if you give a false report, you're going to get it. Now, misprison of a felony is not a term I've seen in North Carolina. But again, let's suppose that bank robber is running down the street. He comes to your door and says, "Hide me." You let him in the house. You hide him from the police. They go by because he's hiding. Then he leaves the house. Yeah, you've become an accessory after the fact. Now, North Carolina has several tampering statutes about tampering with juries. Okay, on that note, we're going to leave it there, and that's going to be Chapter 4, and I will pick up with Chapter 5 coming up. You all have a